rights that go with trial, the right to a speedy and public jury trial, the right to be represented at trial by a competent attorney. You give up the right to have that attorney cross-examine the state's witnesses. You give up the right to subpoena witnesses and force them to come to court and testify. You give up the right to appeal any conviction that results from the change of plea. You're also waiving any claimed constitutional violations which may have occurred either in the investigation or the prosecution of the case. In order to get the benefit of this agreement, are you making a knowing and voluntary choice to give up each one of those rights? I told you what the statutory penalty is, but there can be other consequences that go beyond that. If this results in a felony conviction, after the day you were committed convicted of another felony, this felony will be used to enhance or increase the penalty of that other felony. Any criminal conviction can have an impact on your ability to get certain jobs, certain livelihoods, grants, scholarships. What you have to be aware of is that once I accept this plea, it doesn't matter what those other consequences may be, you won't be allowed to withdraw from this plea. You understand that? Knowing everything you know that you want to enter into this plea agreement. Mr. Shattuck, sir, you investigated whether there are any possible immigration consequences.
Yes, sir. Ms. Sandoval, the U.S.
That's true, Ms. Sandoval.
Yes.
This is a no contest plea. Say what's the factual basis of it?
That on or about August 21st, 2014, in Bernalillo County, New Mexico, we both named defendant intentionally had heroin in our narcotics drug, which is a Schedule 1 or 2 controlled substance, in the possession, knowing or believing it to be heroin, or believing it to be some drug or other substance, the possession of which is regulated or
So you
prohibited.
read the charge statute to them. What are the facts? She had what?
She had heroin, Your Honor.
You're in this county?
Yes, Your Honor.
Mr. Shattuck, sir, are you satisfied that there is a substantial factual basis to support this plea?
Your Honor, I believe that we went to trial and the state presented the evidence that they have that Ms. Sandoval Pierce's claims are illegal.
Ms. Sandoval, how do you plead the possession of a controlled substance? Ms. Sandoval is aware of her rights. She's made a knowing and voluntary waiver of those rights. Please not the conduct of any improper force or coercion. All promises made are in the plea agreement document. And there is a substantial factual basis to support the plea. I'll accept the plea. State anything for sentencing.
Your Honor, we would like to stick with the plea agreement. I understand the penalty as for conditional discharge. Given the fact that she has no usable priors and no known pending cases with our office, I would ask for 18 months of reporting, 18 months of arrest probation to the first report on conditional discharge.
Please, I'll ask you to do it. And tell the reporter your name, please.
Angel Guara, last name spelled G-U-E-V-A-R-A. Your Honor, Ms. Sandoval complained she was on a trial. She is member of security inside the administration. She has always shown up on time. She has completed everything she's been asked to do from the court. She completed treatment back in May and is also continuing to continue treatment on her own. She feels that is to her benefit. She's really been the model client. She's done very well, and I'm very proud of her.
Mr. Shattuck, sir.
Your Honor, I would ask that the court grant Ms. Sandoval conditional discharge. She's done criminal services for a little over a year, I think. She's been doing extremely well. She's kept in contact with me. She's really interested in going forward without the problems that have caused this. She's worked very hard. She's had some real trauma in the past. She has some learning disabilities that have made her life really difficult, but she's got some support now, and I believe that probation control can guide her through the safety months, guide her through it, give her the drug counseling that she needs as they decide. I know she's done extremely well, as Mr. Vada said, on pre-trial services. I would ask that the court grant her a conditional discharge.
Ms. Sandoval, you have the right to make a statement if you wish. You don't have to say anything, but if there's anything you want me to know now, it's time to know. State, what track do you believe this case should be assigned to?
Track 1, Your Honor.
Mr. Salazar, you agree, sir?
I agree, yes.
All right, so we've got 6 months from September the 15th to make something happen on this case. So it must be resolved by March 15th. We'll schedule it for trial on February the 22nd, 2016. If there's any scientific evidence in this case, it needs to be made available to the defense by October the 19th. Is the state going to be responsible for setting up pretrial interviews?
Yes, Your Honor.
Those must be concluded then by December the 18th. Mr. Salazar, please work with Mr. Carrillo on getting those scheduled. Deadline for filing pretrial motions will be December the 29th. Responses will be due January the 8th, 2016. We'll have a hearing on those sometime during the week of January the 9th, 2016. The last day I'll take the plea on this case is January the 29th, 2016. If you guys get a deal worked out early, let us know. We'll take it as quick as we can. Otherwise, we'll have a final pretrial conference on February 5th. That's what I'll expect in your final trial witness list, proposed jury instructions, your deadline for any language assistance or access. Anything else today, Mr. Sullivan?
No, Your Honor.
Okay, sir.
Oh, I don't recall if you answered us on the question of ordering 18 people.
I'm going to order to deal with scheduling first, and I'll address that. Anything else I think scheduling?
Not from the state, Your Honor.
I'm going to order that while held in the Metropolitan Detention Center, that Ms. Jacobs can enter and complete the APT. Anything else, Mr. Sullivan?
No, Your Honor.
Thank you very much.
Thank you, Judge. Thank you, trial, sir.
Yes, today. Item number 4, Jonathan Jones. You have your next to address.
Yes, Your Honor. Vincent Ward and Frank Davis on behalf of Mr. John Jones.
We're here for, I believe, an arraignment to change the plea.
Yes, sir.
All right. That is, did your client waive arraignment on this matter?
Yes, Your Honor.
He waived the preliminary hearing. Mr. Jones, sir, are you under the influence of any medication or anything that would affect your ability to understand what we're doing today?
Yes, sir.
I've been handed this plea and disposition agreement, and on the 4th page, there are 2 signatures. The top signature, sir, can you see this?
Yes, sir.
Is that your signature?
Yes.
Before you signed this document, did you read it and discuss it with your attorney?
Yes.
Did they answer all of your questions?
Yes.
Does that signature mean that you've read, understand, and agree with everything in this document?
Yes, sir.
Has anyone threatened you or forced you in any illegal or improper way to make you enter into this agreement?
No.
Has anyone made any other promises to you about this matter that aren't written in this document?
No, sir.
According to this, you're going to plead guilty to one allegation of leaving the scene of an accident with great bodily harm. That's a 4th-degree felony. A 4th-degree felony has a statutory penalty of 18 months in the New Mexico Department of Corrections, followed by 1 year of parole and the possibility of a $5,000 fine. The state's made a number of agreements. You're not going to be prosecuted on any other possible charges. You're also agreeing that you'll be placed on probation are the terms and conditions set by myself for a period of up to 18 months. They're also not taking a position. Why do you do that, King Todd? I mean,
Yes, sir.
like, you know, we don't take a position. You either agree or you disagree.
Well, on this one, Judge, we're going to leave it in the
Well, it's always in mine. You're not giving me anything I don't have. Anyway, it's gonna be up to me whether it's a suspended sentence, a deferred sentence, or a conditional discharge. Is that your understanding of this agreement, sir?
Yes, sir.
You give up a number of rights if you accept this plea. You give up the right to be presumed innocent. Because this is a guilty plea, you give up the right to remain silent as to the facts surrounding this one specification. You're not giving up that right as to any other matters. You do give up all the rights that go with the trial. You give up the right to a speedy and public jury trial, the right to be represented at trial by a competent attorney. You give up the right to have that attorney cross-examine the state's witnesses. You give up the right to subpoena witnesses and force them to come to court to testify. You give up the right to appeal any conviction which could result in this change of plea. You're also waiving any claimed constitutional violations which may have occurred either in the investigation or the prosecution of this case. In order to get the benefit of this agreement, are you making a knowing and voluntary choice to give up each one of those rights?
Yes, sir.
I've explained the statutory penalty to you, but there could be other consequences that go beyond the statutory penalty. This is a felony offense. If this results in a felony conviction, then after today, if you were to commit and be convicted of another felony, this felony could be used to enhance or increase the penalty on that later felony. Any criminal conviction can have an impact on your ability to get certain jobs, certain licenses, certain grants, scholarships, security clearances, you know, whatever it is. But we may not even know about it, but what you have to be aware of, sir, is that once I accept this plea, it doesn't matter what those other consequences may be. Once I accept this, you can't withdraw from this plea or change it. You understand that?
Sir.
Knowing everything you know, do you want to enter into this agreement?
Yes, sir.
Excuse me. Mr. Ward, sir, you investigated whether there are any possible immigration consequences.
Yes, sir. There are any
Immigration consequences.
As to the factual basis, sir, how would you like to establish that?
Sir, we stipulate.
Mr. Quintana, does the state accept the stipulation to a substantial factual basis?
Yes, sir, we do.
Mr. Jones, sir, how do you plead to leaving the scene of an accident as charged in count one?
Guilty.
I find that Mr. Jones is aware of his rights, made a knowing and voluntary waiver of those rights. The plea is not the product of any improper force or coercion. All promises made are in the plea agreement document. I accept the stipulation to a substantial factual basis. I accept the plea, and we'll talk about whether I find him guilty or not in a moment. Anything for sentencing state?
No, Judge.
Mr. Ward, sir.
Sir, there are two big issues that you must exercise your discretion about. One are the terms of probation, and the other is the conditional discharge. The defense is taking a position on the conditional discharge, as did the victim in this case. And she recommended to you, Your Honor, that Mr. Jones receive a conditional discharge because of his behavior after this accident. So there are two things I want you to consider. One, when Mr. Jones talks to you when I'm done, you're going to see that he takes full and complete responsibility, he's not making any excuses, and he understands the repercussions of what happened. And he's willing to do what the court requires him to do. What I'd like you to know, Your Honor, is some of the facts and circumstances leading to this. After the accident, shortly after the accident, I was retained as counsel. Once I was retained as counsel, Your Honor, I reached out to the police to let them know of John's whereabouts and that he was available. Shortly after that, the state issued an arrest warrant. APD issued an arrest warrant. John complied with the arrest warrant by voluntarily complying and going down for the arrest. Afterwards, Mr. Jones did everything he possibly could to make amends for what happened. He hired counsel to reach out to Ms. Sonnenberg. He did that on his own to resolve and make her whole, her injuries. 2, he instructed me to approach the state to find a way to resolve this case without the state having to use its resources to try him. Where we are right now, Your Honor, is approximately 4 months after the accident. I've given you information that Ms. Sonnenberg has thankfully recovered from her injury, and that she will not suffer any permanent results from that injury. The collateral consequences of a conviction, a felony conviction for Mr. Jones would be immense. It's publicly known that Mr. Jones is a professional athlete. In his sport, he's regulated by public entities, by public bodies that take into consideration felony convictions. He's required, as part of doing this work, he frequently travels and often travels outside the country. A felony conviction could have significant consequences for Mr. Jones' ability to travel, not only out of the state, but frankly out of the country. He does a lot of work with kids. During this period of time, I've given you a letter, Your Honor, from one of his coaches. And during this entire time, Mr. Jones has continued to assist his teammates. He's continued to be involved in the community, to use his profile to reach out to and relate to kids and let them know about how they can avoid doing some of the things that John has found himself doing. I think that this has been a huge wake-up call for Mr. Jones. This has been a huge wake-up call for Mr. Jones. And I'm very confident, Your Honor, based on his, based on the way he's handled himself since all of this has happened, that you won't be regretful if you give him the opportunity through a conditional discharge. I would like to, excuse me one second.
Dominic, you didn't have some coffee?
Sorry, I have a little cold, Your Honor, so.
Need some water?
No, I'm fine, thank you. The second thing I'd like to talk about are the conditions for his probation. Mr. Jones understands that he will be under the supervision of the probation office, and he welcomes that supervision. And frankly, from my perspective, Your Honor, I think it'll be good for him to go through that. For him to give public confidence that he's redeemed himself, that he's remorseful, that he's going to be a good, outstanding citizen. Prior to this time, Mr. Jones has been seeking out help for himself. He's done counseling in the interim period to help with some of his decision-making processes. So I'm quite comfortable that Mr. Jones is going to be able to comply with the standard terms of the condition of probation. There are a couple of items, Your Honor, I would like to just raise with you because they are important. One deals with the issue of travel. Mr. Jones trains here in Albuquerque. His gym is located here. He resides in Albuquerque. But in order for Mr. Jones to do any of his work requires him to travel. And my experience has been that from time to time it could be an issue dealing with a probation officer on travel. And Mr. Jones's job is different than most people. So I think it would be useful to spell out in the terms of probation that Mr. Jones is able to freely travel for his work-related activities, which can include promotional activities, actual fights. Sometimes he requires doing training activities and health-related things outside the state. I think it would be useful to identify those to assist the probation office with his supervision. The second thing is most of these promotional activities and fights can take place in establishments like casinos and places where alcohol may be served. And one of the standard conditions is that Mr. Jones is not supposed to go to places like that. Well, that would make it virtually impossible for Mr. Jones to comply with his obligations under his contract to go do these things, to do the promotional activities and the fights. The third issue that I'd like to raise, Your Honor, and it does relate to the conditional discharge, is Mr. Jones is a public figure. He lives in Albuquerque in a location that is publicly accessible. at his first appearance, his information was released publicly, and since then, he's been subject to various harassing activities. One of the terms of probation that we would like your special consideration of, Your Honor, is if the court is amenable to granting a conditional discharge, that John be allowed to have one firearm for home defense, that he make it known to the probation officer, who's aware of it and has the opportunity to inspect, but is aware of its location. It's just a different situation, Your Honor, and it's hard to explain. I understand it because I represent Mr. Jones, but it really is a different world for a professional athlete and somebody like it is for Mr. Jones than it is for somebody like me. Your Honor, I think that Mr. Jones has suffered a lot through this, but due to his own fault. He was suspended from his sports league. There isn't any assurance whatsoever that he will be reinstated. He entered into this plea and resolved his issue with Ms. Sonnenberg knowing that he would still be subject to a criminal case. So when he did all of that, he knew it wouldn't change the outcome of having to stand here before you today. He did it anyway because he wanted to be accountable. He has lost a lot. He's lost a lot of money. He's been humbled and embarrassed by all of this. And I know that Mr. Jones sincerely wants to move on. He wants to make amends. He wants to be an example. He's a young guy. He's only 28 years old. He has his life in front of him. He made an awful, awful mistake that resulted in an injury. But ever since he walked away from that car, he's done everything he possibly can to make amends for it and to prove that he deserves a second chance, Your Honor. So we would ask that you seriously consider giving him a conditional discharge and putting his future in his own hands so that he has the opportunity to set his own path.
Co-counsel, I mean, you're standing there looking sharp, or you just here to get on TV, or you...
No, I don't have anything to add, Your Honor.
Mr. Jones, sir, you have the right to make a statement. You're not required to. There's a lot of good reasons people rely on their lawyers. Some should rely on their lawyers. They're afraid that their words may not match their thoughts, or that they'll inadvertently say something that's just because of word choice will harm them. I don't hold it against people that choose to rely on their attorney. I won't hold that against you. But if there is anything you do want me to know, now's the time to tell me something.
I just want to start by apologizing to the court.
Well, man, you didn't do anything to me. I got paid to be here.
Well, that's true. You know, I'd rather not. I want to apologize to Ms. Sonnenberg's team, all the officers who were involved that day, all the people who support me, who I've embarrassed, my family, my supporters, mainly Vanessa Sonnenberg and her family for all the heartache that I must have put them through. I am here to accept full responsibility for what happened, for my actions, and I'm just really hoping that you guys can give me an opportunity to redeem myself.
Anything else?
No, sir.
Anything else, defense?
One last point, Your Honor, is with respect to the felony conviction is Mr. Jones does a lot of work with kids. And I think that a felony conviction, for instance, the Boys and Girls Club, he does a lot of work here with the Boys and Girls Club. I think that this is an opportunity for you to order some time for him to spend with kids and to learn from his mistake. And I think that, you know, a felony conviction, in addition to all the other repercussions, could potentially affect his ability to work with that organization.
Mr. Kingtown, any replies, sir?
Yes, Judge. I think we have to say no to the firearm. I don't think there's been any credible information that's been put on the record today that establishes the need for a firearm. With respect to travel for employment purposes, don't have a real issue with that. I think probation could probably determine exactly what the needs are of defendant as to travel, including promotional. And I think the same would hold true for the alcohol if he has to go to a certain establishment where alcohol is served. But the court asked a little while ago about the taking a position, Judge. We kind of did. We agreed to probate the case, but left the remainder to the court. I think they established the case for a conditional discharge.
I'm going to accept this plea without an adjudication of guilt. The defendant's admitted to the act. I'm going to grant the conditional discharge. Mr. Jones, you got real lucky, and in a number of ways. I'm going to adopt some of what Mr. Ward's recommended. I mean, I think you need to talk to young people. Because making one stupid decision changes your entire future. I mean, you had it all. You were a champion of what? Light heavyweight?
Yeah, 9-time world champion with light heavyweight division with the UFC.
Right. I mean, you had it all. You worked hard to get there.
Yes, sir.
And then you do something stupid. I mean, you didn't wake up on the morning of April 26th and say, I think I'm going to flush my career and my future down the tube.
Totally did not.
You know, and that's what you need to make aware when you're talking to these kids. You know, is that it's there. You can't do those things. You're lucky that Mr. Quintana is dealing with the case. I mean, I've known Mr. Quintana like 20 years. He will treat your case like every other case. There are some prosecutors who would be screaming, I need to make an example out of this person. I want to embarrass him. I want to shame him. I want to drag him down as far as I can to make an example. Mr. Quintana is not that kind of a prosecutor. He's been fair to you. He's treated you just like everyone else who does one criminal thing or one thing the law declares to be a crime. You can't ask for more than that to be treated like everyone else. So without an adjudication of guilt, I grant the conditional discharge as required by the plea agreement. The defendant will be placed on supervised probation for 18 months. I'm going to make that for up to 18 months. I got to deal with the probation department. I don't get it. They don't get involved in my business, and I try not to get involved in their business. You'll be supervised on whatever level they feel is appropriate at the time. Anytime they feel that, I mean, they can take it from wanting to see you every day to wanting to hear from you once a month. I don't care. That's up to them. They can convert this to unsupervised probation anytime they want to. I also give probation the authority, as I do on every conditional discharge, is at any time they feel that further supervision is unwarranted, they can apply for an early successful discharge from probation. I'm going to put some conditions on that, though. Thank you, sir. When you talk about promotional travel, what are we talking about, Mr. Ward?
Your Honor, typically pre-fight, his league and other sponsors ask for him to travel in order to promote the fight and other events. He, part of what he does is he does have the opportunity to sponsor businesses and products and things like that. And under those contracts, they ask John to go out and talk about the product or talk about the event, and that's usually outside the state of New Mexico. And a lot of times it can be overseas.
I do charity events.
And as Mr. Jones just informed me, he's often frequently asked to do charity events outside the state of New Mexico to travel for those things.
will authorize travel anywhere that's connected with his work. He's not been convicted of a felony. Because he's not been convicted of a felony yet, there is no effect on his Second Amendment right to keeping firearms. The 18 months, that comes down to 72 weeks. I'm going to require the defendant make 72 appearances. And doesn't have to do one a week. And I'm not talking about any monster thing. You work with the Boys and Girls Club. Your agent's going to reach out to every grade school and every middle school in Bernalillo County and make an offer that you're willing to come by and tell them about the importance of doing the right thing all the time.
I better work on my public speaking.
Pardon me, sir?
I better work on my public speaking.
Well, I mean, you're talking to kids. That's not public speaking.
Yeah, that's true.
You know, I mean, you're in a unique position. Not only, I mean, you get this because you didn't, you know, like I said, you stepped up and said, I did something wrong. You tried to make it right. But you still did something wrong. And you're a person that many of these kids will know of. So Boys Club, Girls Club, all the grade schools, middle schools. You reach out to every martial arts academy. Because I know many of them have classes for young kids or young people. And just tell them that you come by and talk to their students. I don't want you to, we're not about training. I don't care, you know, that they'll have coaches or teachers to do that, but I want you to let them know, you know, how hard you worked, what you did to get where you were, and how making one bad decision could have taken all that away. Let them know. I mean, I know nothing about your childhood, your family, your background, but I know you worked hard to get where you were.
Absolutely.
And you just point out to those kids, work hard in school. Work hard because you can do whatever you want to do. And let them know the risk. I mean, it's when you stand there in a classroom and they see you, they know who you are and where you work. I don't know how many lives that'll touch, but I'm going to require 72.
Sure.
And whether it's go to, you know, like Warriors Coach Kimbo class and talk to his kids, or just reach out to all of them, tell them you're here. I don't want you teaching them how to do, you know, rear naked choke over or anything. That's not it. I want you to tell them what it takes to get to be on the top and how easy that is to lose. Once you've completed and documented the 72 appearances, I want to be informed of that event. And the reason for that is under the rules, I can't modify or change a sentence. It takes a motion within 90 days of the sentence. But I still retain jurisdiction over conditions of release. Once these 72 appearances are completed, I'm going to hold a hearing, and we'll look, you know, on here from probation and everybody else. We'll see where things are at that time. So get out, you know, in the old days, I guess I'm telling myself, we said get out the yellow pages start calling every, you know, martial arts place, and boxing club, and, you know, that yellow pages, I don't know how you're gonna do it, but you better make it happen, all right?
Sir.
Because I've not yet found the defendant guilty of anything, there'll be no fines, no fees, there'll be no probation cost on this matter. Have I overlooked anything, Mr. Ward?
No, Your Honor, I would just reiterate what I mentioned previously about any public documents that may contain Mr. Jones's address being redacted to protect his privacy, because it's likely some of this information will be on the internet.
And, well, one, all the personal identifiers should be redacted on anything. Anything else, sir?
No, Your Honor, thank you very much.
Anything else, Mr. Pincon?
No, sir.
Good luck, sir.
Thank you, sir.
Thank you.
Item number 2, Richard Alagone.
Guinevere Rice on behalf of the state.
Jason Wheeler for the defendant who is present. Your Honor, I apologize. I got caught up in Judge Nakamura's courtroom.
Cost you, Yes. All right. So what's the nature of the electronic compliance
Monica Baker, Pretrial Services. Yes, Your Honor. He was remanded for drinking